After Judicial Watch won their appeal in the case of Sturgeon versus Los Angeles County, the Los Angeles Superior Court judges got one of their buddies to rule in their favor so they could keep their illegal $57,000 in annual payments. Once again, Judicial Watch took their appeal to the California 4th District Court of Appeals. Full disclosure was there to record the oral arguments in what has become known as Sturgeon II. Representing Judicial Watch, Sterling Norris clearly laid out their reasons for their appeal.
The first being that the extra did not fit the extraordinary session, didn't fit the language. The second one is what I call Sturgeon I, that there's a violation of the standards and safeguards of that. And thirdly is the equal protection argument.
The three justices seemed to challenge the arguments advanced by Judicial Watch.
There are numerous benefits. I think all parties pointed that out in their briefs in the first rounds of briefing. You know, every county, some counties pay out of their court funds, some counties pay directly.
Does the legislature have the legal authority in prescribing judicial salaries to prescribe different salaries for different counties?
We didn't say that there could never be variation in compensation.
The issue was Senate Bill SBX 211, which was passed in February of 2009 during an emergency session of the California legislature as part of the budget crisis. The bill was slithered in by the Judicial Council very quietly in the middle of the night while everybody was yelling and screaming about the budget, so nobody heard about it. It was quietly passed and signed by the governor without discussion. And it immediately gave retroactive criminal immunity to the judges for having taken the illegal payments for the past 20 years. These payments, the appellate court had declared unconstitutional back in November of 2008 in the case Sturgeon versus the County of Los Angeles, or Sturgeon I.
I think, Your Honor, to implement what Your Honors have declared unconstitutional, to come back with a legislative fix for L.A. County is not the proper thing to do.
The Honorable Appellate Court Judge Tricia Benke was the presiding judge at the hearing. She questioned Mr. Norris about the propriety of the legislature considering SBX 211 during a special session supposedly called to hear the budget issues.
The special session, did that go properly? Was it proper? And
no.
Well, the proclamation was proper. The question is whether or not what they did with regard to compensation fit within that. And your response would be no.
Yeah, but if Your Honor's question deals with the extraordinary session, and certainly the section of that session said in the proclamation of the governor to consider and act upon legislation to address the economy, including but not limited to efforts to stimulate California's economy, create and retain jobs, and streamline the operations of state and local government. And if one can stand up with a straight face and say, Sturgeon comes within that purview, I suggest it cannot, it is not common sense, and it should never have been considered.
Jones Day attorney Elwood Louie was an appellate court justice. He's now representing L.A. County. He was trying to maintain the extracurricular payments to the judges. He defended the passage of SBX 211 without any reference to amending the California Constitution.
Well, I think you could try to say it was quite alarming to many judges throughout the state of California that we had Sturgeon I. And so we want this court.
It was very disruptive.
This court specifically said it's not an onerous task. The legislature can address it. And as Michael Jordan used to say in his Nike commercials, just do it. Well, that's exactly what the courts and the legislature got together, and they passed this act. The governor approved it and was signed.
Sterling Norris provoked an interesting question from Justice Neres.
What language would you suggest be used to have the state of California focus on this issue and resolve it?
I would say that find XB 211 unconstitutional, based on Sturgeon I, that you have no fundamental policy, you have no safeguards, and make them come back with that.
Apparently, the justices didn't feel that motivated. Justice Nares proposed delaying their decision.
I wonder if we should withhold issuing an opinion for a while and see what happens.
He is suggesting that the court could dodge the responsibility in hopes that the immovable California legislature could possibly figure a way around this mess. It's apparent that the judges really don't want to cause any more disruption, as Justice Benke described it. Apparently, they've taken a lot of heat since ruling against the judges in Sturgeon I.
I don't think this is the last. I foresee a Sturgeon III coming down after legislature acts. And I'm sure we'll see all of you again.
After the hearing, we interviewed Mr. Norris to get his response to the delaying tactics. Talking about a Sturgeon III, did that kind of, were you expecting that they were going to drag this out that long?
No, they will try to drag it out and try to drag it out. And it all depends really on the strength of the judges who make the decision.
He was incensed that the court didn't appear to want to act on this appeal. We asked him what he really wanted from the court.
I was asking them to declare it unconstitutional. And they were dragging on about, well, how long do we wait for the legislature to act? I'll tell you how long it will take them to act. If you declare it unconstitutional, tomorrow there will be action.
What ruling did he think he was going to get from this court regarding SBX 211? We asked him.
They could piecemeal, uphold certain parts of it, declare other parts unconstitutional. But we'll just have to see.
Paul Orphanides, the Director of Litigation for Judicial Watch, accepts the fact that this issue isn't going to be resolved in the near future. The LA judges won't give up their extraordinary bonuses without a prolonged and protracted fight. Being funded by the court, they'll never run out of money and resources to hire the top litigators in the nation to continue the fight all the way to the Supreme Court. The comment was made that this might end up with a Sturgeon III.
Sure. I think that was one of the justices who made that comment.
And what does that mean?
I think it means the judge thinks it's not going to be over whatever decision the court makes today. There could either be an appeal to the Supreme Court, and I expect either party, either side, win or lose, what's going to happen is they'll ask the Supreme Court to review this court's decision. But the other idea is that there'll be additional litigation, either in the context of this particular lawsuit or another lawsuit that will be filed.
We asked him how long this court will stall before they rule on his appeal. He was optimistic.
We expect the ruling. It could be, within a matter of weeks. It could be a couple months, but in the not too distant future, we should be getting a ruling, and then we'll see what happens there.
Sterling Norris thought the whole issue of the Los Angeles Superior Court judges demeaning their office by squabbling over money was reprehensible. But apparently, if the amount of money involved is great enough, even so-called honorable judges will get their robes dirty.
That they got this money that should never have gone there, and they continue to draw those benefits at excess right now, $50,000 more than any other state judge, and with their state salary, they're the highest paid trial judges in the nation.
But Mr. Norris was hopeful that the appellate court judges would be more honorable.
I would hope that they would stay in the spirit of Sturgeon I and do what they should do and very simply declare it unconstitutional.
We here at Full Disclosure want to bring to light a couple of issues that aren't being addressed by either party. The California State Constitution sets forth that all Superior Court judges are employees of the state of California, and compensation and benefits are to be paid by the state. Senate Bill SBX 211 attempted to change the Constitution by declaring payments from LA County to the judges are illegal without amending the Constitution. Amending the Constitution requires a vote of the people. Another question that begs attention is, under what authority can Senate Bill SBX 211 provide retroactive criminal immunity from prosecution to the judges? These judges who have accepted some $300 million in payments that were forbidden by the Constitution. There are laws prohibiting ex post facto laws. Immunity is something you grant to a party before an act is committed, not afterward. Why is it that no one is discussing these very significant concerns? I'm Leslie Dutton, and we here at Full Disclosure will continue to bring you the news behind the news. Thank you.